The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. 3 cases are submitted this afternoon. Those cases are State of Iowa versus Bradley Wickes. The second case is Wesco Agronomy Company versus William Wollenson and others. And the counter or cross claim Iowa Plains Farm versus West Central Cooperative. And the final case is Alexander Sharansky versus Tatiana Sharansky versus Vadim Shapiro and others. That last case is now submitted to the court without an oral argument, and we'll proceed to hear the arguments in the first case. Mr. Mayo.
May it please the court, counsel. Good afternoon, justices. My name is Eric Mayo, and I represent the appellant in this case, Bradley Wickes. He's thankful that this court has decided to retain the case and offer the opportunity for oral arguments on the matter. This case deals with questions of what conduct we should penalize so as to protect our students from it. We argue, respectfully, that we should not so punish hugs and that the legislature did not intend to do so. Hugging, as it happened in this case, does not constitute sexual conduct as contemplated by Iowa Code Section 709.15 sub 3 sub A and B. The district court here found that the hugs that Mr. Wickes engaged in with the alleged victim in this case weren't just hugs, but that they were more than hugs because they involved a sense of emotional gratification. They involved a sense of sexual gratification. I believe that that is a misreading of the facts, and I believe that that is a misreading of State versus Romer. The court, in its ruling, refers to State versus Romer, a case before the Supreme Court in Iowa in 2000.
I have a question here. Can you look at the hugs in isolation from the other things that were going on between these two people?
I believe it should be looked at in its context. The hugs here, though, are the sexual conduct, or it would have to be, let me put it that way, the sexual conduct that the court is referring to in its ruling. I think they are an integral part of the court's ruling, and the only way at which a violation of 709.15 is reached.
Well, right, but there are all kinds of hugs. I mean, there's you hug your grandparents when you're a little child. It doesn't have any sexual implications. But we all know that there are other kinds of hugs that are sexually charged. And frankly, reading through the emails, they got increasingly sexually charged. Why wouldn't a fact finder make the inference from the 600 and some emails with the accelerating sexuality in them that the hugs in question here were not of the grandparent kind, but were sexual in nature?
And Your Honor, my argument is not that these hugs were of the grandparent kind. I think that reading through the text messages, it's clear that there's an emotional bond between Mr. Wickes and the alleged victim. But I don't know that we can at once go as far as to say that they were in and of themselves sexual conduct.
The sexual conduct is defined as any sexual conduct of a student for the purpose of arousing or satisfying the sexual desires of the school employees. Now, couldn't a fact finder make the factual finding or the inference based upon all those emails that the hugs are just a way for the school employee, which is the teacher in this case, of satisfying his sexual desires?
I think if there were more than what is here, that's a possible inference, but my argument would be that we should not go as far as to say that the
possible
hugs
inference leaves him guilty because you just need substantial evidence, and circumstantial evidence is as as telling as direct evidence.
Yes, Your
And
Honor.
if the jury can make that reasonable inference, this time it was a court, but the finder of fact can make the reasonable inference, where does it leave you?
And, Your Honor, I think in this case, it leaves us without substantial evidence that would suggest that these hugs in and of themselves, even taken in the context of the broader text message history and the relationship between Mr. Wickes and the alleged victim, were anything sexual. There's undoubtedly sexual banter in these messages, and descriptions of the alleged victim as being hot, I mean, what have you. At the same time, the hugs themselves are presented in a way, and I think were experienced by the parties in a way, as emotional, as supportive, as encouragement, and as something that was emotionally gratifying. And that is where I think that the district court misread Romer, in that it's equating emotional gratification here with sexual gratification. There's no sex act, and that is not argued by anyone in this case, that there was any sexual act between the parties. And at best, taking the state's argument, which I think comes in their brief, that this was a part of a scheme of conduct that would have eventually led to sexual conduct, I think proves the point. There was no sexual conduct as we would typically see it here.
You need sexual conduct to convict under 3A1, the pattern or practice or scheme, if it's headed in that direction?
Your Honor, I believe that you do. Ultimately, the phrasing of that section I don't believe is entirely clear. The state argues, I believe, that the use of the word scheme of conduct makes it akin to attempt. Well, the word attempt is not used here, and the other two words in that section, practice or pattern, would tend to show that there was a completed act, a completed sexual conduct on the part of the school employee. I think the district court here misreads 709.13 by effectively reading out sexual conduct from the statute. It does read that sexual conduct with a student must be for the purposes of arousing sexual desires. Not that any conduct done with the purpose of arousing or the effect of arousing sexual desires would suffice. And here I think that is where the district court misreads it.
What do we do with the language that says sexual conduct includes but is not limited to? And then there's a list of 3 things, and I agree, it's not any of those 3 things. It's not kissing, it's not touching as defined by that statutory provision, and it's not a sex act. But what do we do with includes but it is not limited to? How do you limit that language to get to the results you want?
Well, it certainly does call for interpretation. There's no other way of looking at it. But all of those things are arguably sexual inherently. And I don't know that you can make the same argument about a hug in this case. And I don't know that we need to, with this case, draw any fine or permanent lines. We also raise what I believe are important public policy considerations. Hugs in and of themselves, as I mentioned, are not sexual. And in this case, the hugs were public, clothed, brief, by all accounts, and didn't involve the kind of improper touching that we might look at in something that is not akin to, a hug with your grandparents. It didn't have groping or other inappropriate, maybe signs of arousal. None of that's present here. These were mere hugs, and we've described them in our arguments to this point as just that, mere hugs.
Well, what about the text messages and he's talking about I can't wait to see you again and you arouse me when I see you, and I mean just like Justice Apple was saying, there's a context to everything, and the legislature is not outlawing hugs that are of a casual nature or to reassure or comfort someone. They're outlawing the sexual exploitation. How can we ignore the volumes of text messaging that was going on here?
And, Your Honor, I don't believe that we need to ignore the text. I believe that it's proper to consider all of this in the context that it's found. But what I point to is what I think is a disconnect between the hugs themselves, which by all accounts, and there are photographs of these hugs presented with the materials and that were presented at trial that show them to be mere hugs. Now, there are references a number of times, and different people could read them different ways to Mr. Wickes' attraction to the student in this case, and words of support that probably went beyond words of support.
Well, are you saying that the actual physical hug would have to have some sexual appearance to it?
I believe that there would have to be something about the physical hug that would have to incorporate that sexual arousal, that sexual gratification, and that is where I see a disconnect between the facts and the texts and the circumstances in this case and what the statute would require. I'm not saying it's impossible to have a truly bad hug that exceeded all bounds of what is contemplated by the statute and that would fulfill the definition of sexual conduct. We don't have that here, and I would urge the court to consider the danger of ruling that this conduct constituted that sort of sexual conduct contemplated by 709.15.
But what about the sheer volume of times that we're talking about here? I know the brief makes reference to a few instances, but I think the record really reflects that we're talking about dozens of times, on a daily basis. This is not your normal, I'm using that term in my own way, but that's not the normal way that every time you're with or near this person, you end up hugging this person. That goes beyond what I would consider to be a normal hug.
And certainly, Your Honor, daily hugs are probably not the norm for all of us, but
well, and should that be the norm for teachers? I know that teachers are concerned, or any school official, or any of the people that might be subject to this are really concerned about the fact that, oh, well, gee, I can't go up and give my student a hug or the graduation hug. But this goes so far beyond it, including the instances of being off school premises and meeting off school premises for purposes of getting and giving a hug. Doesn't that make this a little bit unique as well?
It's no doubt unique, and I don't know that anyone would point to this as a typical thing in education or even outside of education to have that many hugs. But we can all, I think, envision a scenario in which someone needs the kind of emotional support or, based on the relationship between the people, would encounter hugs on a daily basis without it being or having a sexual component. And that is really the point at which I feel that the court is misreading Romer and saying that because there's this emotional, and I'm not just saying misreading Romer, but also looking at it somewhat logically, that emotionally and sexually are not the same thing. Emotionally gratifying and sexual gratification are not the same thing.
What if hypothetically, instead of some of these, texts with the sexual banter and sexual connotation, what if there were eyewitnesses that said at the time he hugged this girl that he was making those statements verbally out loud? Would that be?
I don't know that it would be enough to convict. If that in and of itself combines the hugs with a sexual component just through the words alone. And looking at and we relate to a case out of Minnesota, the Ortman case, 466 Northwest 2nd 1st from 1991. And in that case, there was it was under their psychotherapist statute, but that includes the position of pastor. It was a pastor and a parishioner at his church, and he hugged her, and during that hug, he was clearly aroused. And that was also coupled with statements suggesting that the parishioner should leave her husband and be with him. So what we could, I think, clarify and classify as being sexual, a bad hug, as I think the court there describes it. But even they stopped short of suggesting or agreeing with the state in that case that should be criminally sanctioned, because we don't want to, and they concluded that they didn't want to cast the cloud of criminal suspicion or penalty over something that can be as beneficial. and supportive, and is typically a loving and comforting thing.
What would be the danger in affirming the conviction in this case?
Your Honor, I do believe that that would cast a serious question on what is an appropriate hug. If the hugs here did not, again, taking them in the context of the text messages, but for what they really were, clothed, brief, public, supportive hugs, if they constitute the possible sexual conduct under this statute, then I would suggest that not merely hugs, but a wide range of conduct that we take to be supportive and important on a daily basis, not just in public, but also for our educators.
So you're arguing that before a teacher could be convicted of sexual exploitation of a student, the teacher would not only have to hug the student, but there would have to be a sexual component, a kissing or an additional touching or something of that nature. Is that your argument?
That is what we're arguing in this case. I believe that, and my time is about to run out here. I don't know if I can finish the answer.
You may answer the question
Thank you.
somehow.
I believe that in this case, the concern is that, and I'm sorry.
My question was, where do you draw the line? Do you have to have the physical component as a part of the hug?
I believe that you have to have sexual conduct. And if the hug itself does not encounter the arousal, the satisfying sexual component of what is listed in the statute, it would not suffice under 709.15. Thank you.
Mr. Mayo, thank you as well. Mr. Sloven.
Thank you, Mr. Chief Justice, and may it please the court. Counsel, good afternoon. It's a pleasure to be here. Opposing counsel is construing the statute in a way that adds new requirements that are not present in its text. Section 709.15 sub 3 requires sexual conduct with a student for the purpose of arousing or gratifying the sexual desires of either party. Now, there's a requirement that it be sexual conduct, and then the statute goes on to define some examples of what sexual conduct might be, specifically stating that this is not an exhaustive list. And as this
this case reminds me of our old enticing cases, and you were probably in law school or before, not even in law school at the time, but the state was bringing enticing cases where they'd have someone on the phone and they'd make arrangements to meet some minor, and then when the perpetrator showed up at the mall or wherever the meet was, they'd get arrested for enticing. And we basically held that might be attempted enticing, but they weren't really enticed because it wasn't a minor. And here, it sounds more like a grooming type thing that may lead to a violation of the statute. And when does the grooming part cross over to a violation of the statute? And that's the problem I'm having, because, a statute, if we start doing like the U.S. Supreme Court does, I know pornography when I see it. I mean, then you're pretty vague and pretty out there. So what kind of standards would you have us adopt so we can tell in the cases in the future when it crosses this line that the state thinks it crosses?
I think the standard is contained in the statute in our cases that explain when conduct has a sexual characteristic to it, and then in the additional requirement that, first the requirement that it be with a student, and then that it be for the purpose of arousing or gratifying the sexual desires of one of them. What I mean by this is that we have Monk and we have Pearson. We already are familiar with the inquiry of looking into the totality, the type of conduct, and the circumstances surrounding it to determine if conduct is sexual. And we have additional guidance from the legislature here in the form of a non-exhaustive list and guidance that...
But I think you're confusing the two sentences in 3A2. The first sentence says sexual exploitation consists of sexual conduct for the purpose of arousing or satisfying the sexual desires of the employee or the student. All right, that's the first sentence, the arousal part. Then it says Sexual conduct includes but is not limited to, and there's a list of 3 items: kissing, touching in a private area, and a sex act. And you agree this is not any of those. Would you agree?
I actually would say that, and this is getting more in the weeds of these specific facts. If you look at the pictures of these hugs, States Exhibits 2 and 3, and the trial court correctly describes these as not mere hugs where you touch the very upper part of your body and brief pat. These are embraces. The full extent of their bodies are touching: chest, pelvis, everything. So we have touching of the clothed breast, pelvis, and thigh area, which, and I don't think the trial court relied on that alternative. It went straight for the holistic question of, is this conduct that arouses or gratifies Mr. Wickes' sexual desires?
But every time a teacher hugs somebody and their chests touch, it's a violation of the statute, the way you're talking.
No. Now, it is conduct that falls within that list. There are 2 things that stop it from automatically being a violation of the statute. The first is that it's not necessarily sexual conduct within the meaning that this court has imparted to that phrase. And the other is the motive, the specific intent element that it has there, has to be done for the purpose of arousing or gratifying the sexual desires of one of them.
What point in the state's mind do the emails cross the line from emotional dependence? Because clearly these people are emotionally involved with each other. Does that emotional involvement turn into a sexual involvement? I mean, these emails seem to be pretty consistent, and I guess you could read some 2 different ways, but where does it cross the line? I mean, the sheer volume can't do it, because if you're emotionally dependent, you may have it. So where's the language in them that crosses the line?
So there is a large volume, and the trial court gives us a list of 22 of the lowlights that it found. There are more, and we point them out in our brief. I'd say that one of the turning points is this, and I'm going to read it if that's all right. Permission to be a pervy old man. Your eyes are amazing. Soulful, draws me in. And the pervy stuff. Girl, you know you've got a great booty. Below that is some smoking legs that are beautiful and not the scrawny chicken legs like so many others. You've got a pin-up girl build, an hourglass of curves. Read this.
I agree with you, Mr. Sloven, that what he was doing was for the purpose of arousing himself. He deserved to be fired. He lost his job. The question is, does he fall within the statute such that he goes to prison? And the problem I have is there's this list of 3 items, and those seem to me maybe qualitatively different from a hug, because all of those are things that you would never imagine being appropriate between a teacher and a student. Kissing, touching in a private area, or a sex act. Whereas a hug is something that's often appropriate, and that's the concern that Mr. Mail is raising is, are we now going to put a chill on conduct that actually is not socially undesirable conduct in order to target someone who's obviously engaged in serious misconduct?
So I think there are obvious parallels between hugging and kissing. Both of them are potentially expressive of, the light social boundaries, like you can kiss someone as a greeting potentially. I think that the stronger parallel here to something that you may expect is the touching of various bodily areas, and it's easy to envision ways that this could happen in a non-sexual way. In coaching, for example, or in cheerleading, in teaching any amount of physical activities that involve some touching. Also, if there's, if somebody falls, right, and you catch them and you touch parts of their body in catching them, touching of those clothed areas. Now, this doesn't become a crime because the conduct doesn't have that sexual characteristic that we evaluate the totality of the circumstances to find, and it's not conduct that is done for the purpose of arousing or gratifying somebody's sexual desires. Now, I want to talk a little bit about the hugging as an integral part of this case. I think you could find that the statute has been violated even without evidence of the hugs. Romer established that we don't need necessarily physical contact in order to prove sexual conduct under this statute. In light of that, when you look at these Facebook messages and you look at repeatedly, Mr. Wickes is putting out hooks out there to turn the conversation to sexual matters, really heavy sexualized.
But Romer involved conduct. It still involved conduct. That was the difference. I mean, there was no physical contact for, as I recall, some of the charges between the teacher and the students, but the teacher was staging these sex acts between the students and photographing them. So there was conduct. This is purely communications, right?
Well, the conduct in Romer is...
At least, you know, under your hypothetical.
Well, sure. The conduct in Romer is communication of, you know, stand here, do this, and then taking the picture. This is communication, which I would say is conduct, directed towards steering the conversation into areas that would specifically arouse and gratify him and also her. You look at the appendix pages, I think 660 to 665. They're talking about sensual massages and talking about their turn-ons. And then she says, he's describing the things that he would do during a back rub. And she says, this damn dry spell, you're killing me. And then she says, you're doing this on purpose now.
Does the state need to prove sexual conduct in order to convict for a pattern, practice, or scheme?
I don't believe so, Your Honor. And to respond to opposing counsel's argument that pattern and practice evince a legislative intent to have a completed act, I think if you adopt that construction for scheme, it almost reduces scheme to surplusage there. I think that scheme indicates a broader plan and doesn't necessarily require a completed act that would violate.
The pattern and scheme is under sexual exploitation by a counselor or therapist.
It's also included under the sexual exploitation by a school employee in the next section.
That has more severe criminal consequences. That would be odd that the sort of the inchoate crime would be punished more severely than the completed crime. That doesn't make sense to me.
The pattern or scheme is also as described in paragraph 2.
Okay.
It's in both. It's in,
Go ahead, answer Justice Wiggins first.
well, it's
then
in both
answer
2
mine.
and 3. It's in 3A1, I believe, and then it's in the same way that it's in exploitation by a therapist or counselor. And to address the concept, I think it is rational for the legislature to criminalize the inchoate offense, even if it doesn't result in a completed offense, more harshly, because it is such a profound betrayal of the community's trust. And it's not always the case that we punish a completed act without a particularly culpable intent more harshly or even just as harshly as we punish an uncompleted attempt with that culpable mens rea. We use the example in our brief of attempted murder. If you try to kill someone and fail, that's a Class B felony. If you commit voluntary manslaughter, a killing in the throes of and the heat of passion, you have actually ended a life, but because you didn't act with that culpable intent, that's a Class C felony.
In the enticement area, we said you can't, attempted enticement is not enticement, and next session the legislature passed an attempted enticement statute. And I'm just having trouble getting this from attempted to the actual act.
I think that criminalizing the existence of the scheme of conduct itself is an intent to criminalize what's happening while it's still in the inchoate phase, before the completion of an act of sexual interaction between them. And I think that to read it any other way would reduce the word scheme to surplusage in light of pattern or practice. So I think that what this ultimately comes down to on the sufficiency, because what I heard from opposing counsel is that it is possible for hugs in conjunction with Facebook messaging and communication like this, possible for that to amount to sexual conduct and conduct done in order to arouse and satisfy sexual desires. So I want to talk about some of the things that show that's occurring in this case. When Mr. Wickes is interviewed by law enforcement, he denies that he had any romantic interest in the student here. And I think that denial is very probative and shows that he's aware of the inculpatory nature of the communication and the relationship that he built with her.
Well, of course, he's going to get fired. I mean, I think the emails are enough to fire somebody. I would say, at least.
And I think at that point, it had become obvious that was in the cards, and now he's thinking about criminal liability here.
Had he been disciplined or suspended at the time of the interview?
He had already been called to the principal's office and given the principal testified. I think it was the superintendent and the principal, I believe, testified at the bench trial about that conversation. And from their testimony, I think that it's very clear that it didn't go well for Mr. Wickes. I also think that there are very strong inferences to be drawn from his eagerness to get hugs from her, his encouragement, telling her to stop by on a daily basis. Also, if you look at Exhibit 3, and you see that full body hug that I described, then you look at appendix pages 591 and 592, and they're saying that that was a photo op and they didn't get a chance to have a real hug that night. Whatever hug they're describing is something that is more of a hug than is depicted in that picture. And the record doesn't really say what that is, but it must involve some additional level of contact even beyond what's depicted there.
Why shouldn't we follow the Minnesota case, Ortman?
So Ortman includes some qualifying, well, first off, we're construing an Iowa statute passed by the Iowa legislature. Ortman includes some qualifying language saying that if we're talking about a crime committed against a child, then it's understandable that the legislature may want to criminalize hugging that crosses particular boundaries or takes on a sexual characteristic because of the vulnerability of minors, their inability to protect their own interests and the exploitation of that power relationship. Ortman was also distinguished by a later Minnesota case, which I believe is State versus Murray, finding that in that context, there was hugging that had crossed that boundary and was still punishable and criminalized by their statute, notwithstanding Ortman. I think the better out-of-state persuasive precedent would be Hardy from Maryland, which also involves lengthy and extensive communications, and Maryland's definition of sexual abuse in this context actually looks a lot like our definition for sexual conduct in 709-15-3, that it's criminalizing the attempt to use a child for the actor's own benefit.
Would affirming this conviction and 5-year prison sentence have a chilling effect on teacher-student interaction and supportive hugs?
I don't think so. I don't think that we've seen any chilling effect on teacher-student behavior as a result of Romer. I haven't heard of schools needing to cancel productions of Romeo and Juliet out of fear of having school employees directing students to kiss. I think that, and I see my time's expired, if I can briefly conclude. I think that it was apparent even to Mr. Wickes that this is conduct that should not have occurred, that is culpable. The lengths he went to conceal that conduct make that abundantly clear. I think that, and the trial court noted, this is something that all teachers should know not to do. I don't think there will be any chilling effect as a result of affirming. Thank you.
Mr. Sloven, thank you as well. Rebuttal, Mr. Mail?
Thank you, Your Honor. I did want to respond to the arguments made by the state here by noting that I think the danger that is apparent in the chilling effect here becomes even clearer when you consider that the state's arguing that you don't even need the hugs here. The text messages themselves, in other words, would be enough. I think that the only proper read of what the district court did here is that the hugs were integral to the analysis. The text messages, I think, were taken as showing what that meant to Mr. Wickes, but without the hugs, well, I don't think even with the hugs you get to sexual conduct, but without the hugs, there's no way that you get to the sexual conduct under these facts. And it's important because I think that the state is arguing in part that this could be reversed and remanded for further consideration on basically the text messages. If hugs are taken not to be sexual conduct, the rest of it can be sexual conduct. Here it is important to consider the texts show a relationship possibly building. It didn't ever come to the point that there was, in fact, a relationship between Mr. Wickes and the student in this case. What had been discussed, and I think shows importantly that they both understood the limits, is that when they started discussing a relationship, it was understood that that would be after she graduated. In the parallel statute here, 709.15 sub 2, for sexual exploitation by a counselor, there's a time component included in that statute. In subpoint 3, it refers to sexual conduct with a patient or former patient within 1 year of that professional relationship, essentially. Here, that time component is absent. So, at best, taking the state's argument on that these text messages show, the grooming function, that there would eventually be this sexual conduct, would, by its own nature, show that sexual conduct would not fall within this statute.
What about the Facebook exchange that Mr. Sloven referred to with they had the picture of that hug on that day, and then that evening, the teacher Facebooked her and said, "I was hoping to get more out of the hug."
Yeah.
Doesn't that show that there was a purpose that was beyond just a normal hug?
Your Honor, I read that a different way, and I think that there are different interpretations of that really make it unclear what was being said. What was done there was a pose for a photograph. I think that was understood that it was a pose for a photograph. Both Mr. Wickes and the alleged victim are looking directly at the camera, smiling big for the photo. What he said could very well just mean, I just wanted a normal hug rather than a pose for a photograph. I think to read in what the state is inferring there is going a bit too far.
I mean, isn't that for the fact finder? I mean, once we're in the territory where some hugs can be considered sexual conduct for the purposes of the statute, isn't the case kind of over?
I don't believe the hugs themselves are the sexual conduct, and that is really where I think that the court is here on these facts. It's that the hugs were for the purpose of sexual arousal, sexual gratification, and the facts don't really show that even with the text messages. The hugs themselves are framed in a way of providing emotional support, providing that emotional bond. But through all of the text, through all of the messages here, what is lacking is some showing, I believe, that these hugs themselves were some sort of arousal for Mr. Wickes. And we do see that in other cases, and I did mention the Ortman case where there was that arousal component, but even that was not enough. And I do believe that should be persuasive. Obviously, it's not controlling. Obviously, it's a Minnesota case. But I think we find ourselves in the same basic dilemma of what do we want to put the cloud of suspicion on. And I think that Iowa, much like Minnesota and probably elsewhere, we don't really have too many hugs. And for those reasons, I would urge the court to reverse the district court. Thank you, Justices.
Mr. Mayo, thank you as well. The case then is now submitted to the court.